Again, I want to thank everyone for coming to today's webinar of Legal Issues and Emergency Preparedness, Part 2. I want to introduce our speaker today. Rachel Lookadoo is an assistant professor in the epidemiology department of the College of Public Health at the University of Nebraska Medical Center and serves as the deputy director of the Center for Biosecurity, Biopreparedness, and Emerging Infectious Diseases. She also acts as the director of public health policy for the Water, Climate, and Health program at the University of Nebraska Medical Center. Ms. Lookadoo's background is as an attorney, and she focuses on the various legal and regulatory issues that can arise in emergency preparedness and response. She specializes in healthcare surge events, isolation quarantine law, public health impacts of climate change, crisis standards of care, infectious disease response, and general legal preparedness. Ms. Lookadoo also conducts emergency preparedness trainings and assessments for public health departments and healthcare facilities nationally. Ms. Lookadoo received her Juris Doctor degree from American University Washington College of Law and her bachelor's degree from Baylor University. And with that, I will turn it over to Rachel.
Thanks, Thomas. All right, so let me make sure. Okay, so hopefully you're seeing the right screen. Hello, everybody. Thanks for being here today. And welcome to part 2 of this webinar series. This has been really fun to do. So this series is all about legal issues in emergency preparedness. And so today we're going to be exploring how to take some kind of complicated legal issues and turn them into really practical strategies that you can actually use in your healthcare facility or whatever setting you may be in. So in part 1 of this webinar series, which Thomas mentioned, we started the conversation around some sort of key foundational legal concepts and authorities. And today we're going to get into breaking down legalese into plain language, exploring cross-state legal concerns, and looking at federal and state waivers. And then we're going to talk about how this all comes together into operationalizing all of this in a real emergency. Well, hold on. Okay, so I made these disclaimers last time, but I want to say them again, and I probably always will in legal presentations. So I am a lawyer, but I am not your lawyer. None of this should be considered legal advice. I stated this last time as well, but I'm presenting today on what the law says and how those laws are supposed to work in an emergency. I know that that may not be the way things actually go. There may be operational differences. Folks may interpret laws differently, all of these sorts of things. So this presentation is just on what the law says and how it's supposed to work. Another thing I want to say, which again I said last time, is this presentation reflects the law as it is right now, as it currently stands. There's a lot of things changing at the federal level at the moment. So things may change. There are things that I may say today that could change in the very near future, but this is how things currently are. Okay. So back in May, as Thomas mentioned, we did part 1 of this webinar. And in that webinar, we talked about emergency declarations and the differences in federal and state declarations. We talked about Stafford Act, public health emergency declarations, all that good stuff. And we talked about HIPAA in emergencies, some of the key things to remember about patient privacy and information sharing. We talked about volunteer management and liability, and we focused a little bit on Good Samaritan laws and some of the differences across state lines there. So I think I just saw that Thomas put the link in the chat. If you're interested in that material, I encourage you to go back and watch part 1 of the webinar series. That is available to you there. So this time we're focusing on a whole new batch of legal topics. We're going to be talking about translating legalese, cross-state concerns, federal, state, emergency waivers. And so my goal for today is that by the time we're done, I want you to feel comfortable translating this complicated legal language into understandable plain language. To be able to understand and look out for some of the really common cross-state legal concerns that we see in healthcare and public health emergencies, and to have a better sense of how federal and state waivers may be used during an emergency. And just for engagement here, I'd be curious if you want, you don't have to do this, you can drop in the chat the last type of emergency that your organization dealt with. And I'm going to try and monitor the chat. If I see them, I'll try and pull some examples that may be similar to situations that you've dealt with. Okay, so why is this important? Why does this matter? So these topics have very, very real world consequences. It's the 20-year anniversary of Hurricane Katrina coming up. It's crazy to me that it's been 20 years. I've been seeing a lot of things. There's like a new show on Hulu. There's a lot of conversation around Katrina. And so I wanted to pull an example from that. And also, I think Katrina is arguably one of the most impactful emergencies that we've seen in modern US history. So during Katrina, there were a ton of medical providers from across the country, physicians, nurses, you name it, who wanted to volunteer and deploy and help in the response. So people came from all over, they came to Louisiana, and repeatedly they were just turned away because there were licensing and credentialing issues. So this led to actual delays in the medical response. This led to delays in care being provided to people who really desperately needed it and needed it quickly. So again, I just share this to say that for each of the topics we're discussing today, there are tangible, actual consequences of not being familiar with the potential legal concerns and preparing for them. And I ask you to put some things in the chat of emergencies that you've dealt with, and I see that some of y'all have already done that, which I appreciate. But I want you to think about now, and you don't have to put this in the chat, with some of your previous emergency responses, were there legal questions or legal issues that actually slowed down the response? And just think about that, like were there hurdles that came up in legal issues that made it so that your response was maybe not quite as nimble or as quick? And as you think about that, I think that's really our goal for today is the clearer that we can make the law before the emergency, the faster and more effective we can make the response. So we're going to start by talking about how to translate legalese, which I know is maybe not our traditional kind of emergency law topic, but I think it's something that's really important because we have to deal with these statutes and regulations, and they can be really complicated. When I say legalese, I mean that language that you see in laws or in contracts or MOUs that are just really confusing and hard to follow. Because if we understand those words, great. If we don't, it can have major implications for how we actually practice public health, healthcare, and emergency management. Okay, so if you've ever read a legal document or a law and been confused, I want you to know you are not alone. And it turns out it's not your fault. So this is a study that was done in 2022. It was published in the journal Cognition. It was by some researchers out of MIT. And they studied a number of different legal documents, contracts, and they found that the issue was not that the concepts included therein were so complicated that it was impossible to understand. It was really just bad writing. So remember that as you're reading through things and it's legal and it's hard to follow, it's not your fault. It's bad writing. These things are designed to be hard to follow. And on top of this, these same researchers the next year went back and found that even lawyers don't like legalese. Even lawyers don't understand it. So do not beat yourself up if legal content ever feels confusing or hard to follow. You are not alone. It is intentionally very hard to understand. So I want to start with some common terms or words that we see in legal documents or specifically in statutes and regulations. So the first I have on here is notwithstanding. So notwithstanding, this really just means in spite of or despite. So you often see this in statutes that say things like notwithstanding any other provision of the law. And this just means that whatever the current law is, this new law, it overrides any previous law. Those previous laws do not override the new law. Notwithstanding the previous law, this new law takes precedent. I also want to talk about the word whereas. So in common language or in common conversation, you may use whereas as sort of an alternative for although or however. So it can be things like, I prefer strawberries, whereas you prefer blueberries. So it's kind of like that in between however kind of phrase. But in legal settings, that is not how it's used. It's used very differently. So in statutes or contracts, you'll typically see the word whereas being used to set the stage for a new law. It provides this kind of background context information. I wanted to show you an example. So this is from the South Dakota-Nebraska Boundary Compact. This was codified into a statute in the state of Nebraska. And we can see here, I've highlighted all of these whereas clauses. And so these are used throughout this law to introduce explanations and backgrounds for why this law came to be. So this law, actually, I cut it off because it wouldn't all fit on the slide. This law has 15 of these whereas clauses. So it kind of serves as just a place filler to give background info on what this law is about. All right, heretofore or hereinafter, you've probably seen those in contracts or other documents before. Heretofore basically means everything up to this point. Hereinafter means everything after this point. See it a lot in contracts. And then one of the most important legalese terms that I want to draw attention to is the contrast between shall or must provisions and may provisions. This is a really critical difference, and it can impact the enforceability or the consequences of following a statute or regulation. So let me show you some examples. So these are two examples from HIPAA. You remember we talked about HIPAA a lot last time. We're not going to talk about it again today. I'm just using it for examples. But you can see the first statute I have here, this is some language directly from HIPAA, and it's talking about the minimum necessary standard. So the rule that covered entities under HIPAA have to provide the minimum necessary amount of information. And you'll see here that the rule actually says must. So what this means is anything that follows that must, if the covered entity does not do it, there's going to be a consequence. There may be fines, there may be sanctions, whatever the case may be, they have to do it. This is enforceable. Whereas if we go down to the second example, this is talking about whether or not covered entities have to obtain consent if they're sharing patient information for treatment or payment or healthcare operations. And you'll see here, this one says may. So this gives us some wiggle room. Covered entities have discretion here in how they follow this rule. They don't necessarily have to obtain consent for this, but they can if they want to. So if they don't obtain consent, there's likely not going to be a consequence. There's likely not going to be a fine or a sanction because it's not something they have to do. So it's a really important distinction to make. So I did want to go back and just say, I'm curious if there are examples of legalese that you've seen in contracts or laws or wherever that maybe you found especially confusing or annoying, or maybe you have like a favorite piece of legalese, whatever the case may be, feel free to put those in the chat. I am going to check the chat real quick to see if I've missed anything. Yeah, good point. Matthew, who noted that must is often followed with reasonable, which is very open to interpretation. Okay, we'll keep going here. So I want to put this into practice a little bit and actually break down a legal provision, break down a statute a little bit. So the statute that you see on the screen here is the first two clauses of the Nebraska Emergency Management Act. This is talking about the governor and their powers and duties. And when you first look at this provision, when you first look at this statute, it is a mess of words. It's a lot. It's pretty long. I'll be honest, when I was looking for an example statute to use for this slide, it was hard to find one even short enough to put on the slide that I could really use as an example. So these laws are often written in this very confusing kind of way. So there's a lot going on here. So let's try and break it down and make this make sense into smaller parts or make it more simplistic. So who are we talking about here? Who is the party that's really at the point of discussion in this provision? So it's the governor. This whole provision here is focused on the governor and what they can do. There's really no other parties that have a big role in this statute. This is primarily focused on the governor's responsibilities and their power. So let's go to the next bit. So what can the governor do? What is this law saying? It's saying that the governor is responsible in an emergency and can make proclamations or change or waive rules to address emergency management needs. We see a lot of this language in the second provision here. It says they can make, amend, or rescind necessary orders, rules, and regulations. Again, that basically just means they can change or waive rules as needed for emergency management or response. When does this take effect? When is this actually meaningful? So for that, in the event of a disaster or emergency. So we can see that right here. Oh, sorry. We can see that right here, that it says when this actually applies. So what we can take from that is that this very long provision of this statute essentially just says the governor may make proclamations or change and waive rules to address emergency management needs in the event of a disaster or emergency. So a much more simplified version of that. So I want you to take from this exercise things you can use when you're trying to translate a statute or some sort of legal language for yourself. If you're trying to read a statute or regulation, break it into chunks. Don't try and read the whole thing at once. Try and break it into little bits to follow and understand. Look for those key parts, the who, what, when, where, like we just did. What are the key words that really explain what's happening in that given law? One other thing I would say is as you read laws, look for the qualifiers. You'll often see statutes or regulations that say, except for the following. So make sure you actually check those exceptions. They may say things like, except for provisions noted in section 2, subsection B, whatever the case may be. Take the time to go back and look at those other sections and see what it says in those provisions. And then I think one of the most important things to realize as you're dealing with sort of translating legal language is that your goal is not to become a lawyer. Your goal is to become fluent enough to understand this language in a way that allows you to operationalize and act upon these legal structures. So to do that, use the tools that are available to you. One of those things is plain language glossaries. These are available all over the place. I included a link here for the one that the Nebraska Supreme Court provided, but there are plenty of other resources available like this. You can just Google it. But use these kind of glossaries that define complicated legal terms and make them make more sense. I would say here, be very careful to use a glossary that is for legal language. As we saw with that whereas example, words that are used in a legal context can be very different than how they're used in day-to-day context. So make sure you're using that legal type of glossary. And then above all, ask for help. If you know an attorney who's in this space, if you know someone who specializes in more legal concepts, ask them for help in translating these kind of complicated language pieces. All right, let's move on to our next topic. So next up is cross-state legal concerns. So in the US, we often have a real patchwork quilt of state laws, which has its pros and its cons. I think ideally it allows states to tailor laws to their own needs and interest and the interest of their voting public. But it also means that when you're dealing with an emergency across state lines, it can cause a lot of confusion or risk of liability or all sorts of issues because there's big differences across states. I saw something the other day that said emergencies don't stop at state lines, but laws do. And like, that is a good line. That is true. Like, emergencies are going to cross state lines, but the laws may not change. They're going to stick to their boundaries. So let's get into some of the common issues here. So I want to start by asking, why does jurisdiction matter? Why does each state law make a difference? Well, as an example, this map shows different state laws relating to interstate telemedicine licensure, or basically a provider's ability to practice across state lines via telemedicine. And I think you can see when you look at this map, it's a real mix of laws here. When you look at this mid-Atlantic region, there's a lot of different things going on. We've got North Carolina here, which is one of the full state license required, no exceptions to the rules for telemedicine across state lines. Then you've got Kentucky right close by that's a little bit more lenient, but still fairly strict in their rules. But then you've got completely different in Virginia and Tennessee and West Virginia. Excuse me. So I point this out just to say, these sort of things come up a lot. You can see here that when you cross state lines, you may be getting into totally different legal territory than what you're used to in your home state. So one of the primary issues that comes up repeatedly when we talk about cross-state legal concerns in an emergency or an emergency response is around portability of licensure, or people's ability to practice under their license in a state different from where they are licensed. So normally we know that in healthcare, you have to be licensed in the state where you practice. That's pretty clear, that's pretty straightforward. But when an emergency hits, patients don't really care where your license is from. They just want you to be there and able to help. And that may be across state lines. But unfortunately, our current legal system doesn't always move that quickly. It's not that nimble. There are hurdles that need to be addressed. So when we talk about licensure portability, there's a few tools that we have in the US that work really well. So we have these compacts, which are basically model laws and agreements that multiple states sign on to for a benefit for all the states involved. So for example, we have the Nurse Licensure Compact. I've put the map on the slide here so you can see which states have adopted that compact, which is most of the US. So that compact allows nurses to practice across any states who are members to that compact without getting a separate license. Similarly, there's an EMS compact for EMTs and paramedics. That one's a little more limited. I think at this point, only 25 states currently have adopted that compact. But these tools are really powerful because during disasters, they remove a lot of the barriers around paperwork and some of the red tape to get things moving. Compacts don't cover everyone though, and as we can see, even with this map, not all states participate. So we can't assume that license portability will always be an option. In addition to compacts, there's also things like mutual aid agreements or pre-existing MOUs where states make agreements to share personnel resources to address these licensure concerns before they happen. However, sometimes those things aren't in place. So if your state isn't part of a compact, or if you're a volunteer who maybe hasn't been pre-vetted, you might be turned away. There might be significant delays in credentialing. And this is what happened in that example I shared with you from Hurricane Katrina back in 2005. A lot of very talented, enthusiastic, engaged healthcare professionals showed up to volunteer and to help, and they were told that legally they could not volunteer and assist. I saw another example from Hurricane Helene last year, where North Carolina and South Carolina actually very rapidly enacted emergency orders that allowed out-of-state licensed healthcare providers, physicians, and nurses to work immediately so that there was none of that credentialing delay. And so I think that's the sort of thing that we want to work towards more, is having these really flexible legal pathways that are ready to put into place and activate before the emergency occurs. And so I think as you think about for your own facilities, think about, if you needed some type of specialist healthcare provider, or you needed a large number of nurses tomorrow for some sort of response from another state, how long would it take you to get them from where they are legally to the bedside or the patient's room? How long would that process be? And how are there ways to make that quicker and more nimble and more effective? So we touched on EMAC, the Emergency Management Assistance Compact, briefly, I believe, in our last webinar, but I just want to refresh on this because it is really important when we talk about, cross-state legal concerns and these different compacts that are available. So EMAC is essentially a formal handshake between states saying, listen, if you're in trouble and you need additional resources beyond what you have, we will send you help. So when EMAC is activated, it does more than just send over resources. It also covers some of your legal bases. It provides liability protection for deployed personnel and also workers' comp if they get hurt while being deployed. There's some limitations to EMAC, however. It mainly applies to state-owned or operated or controlled resources, so state health department staff, National Guard medical units, etc. It doesn't automatically cover private hospital staff or like NGO volunteers unless there have been other agreements made previously and that are in place. I think the biggest limitation to EMAC is that it's not automatic. What has to happen is this process you see on the screen here, where a state has to declare an emergency, there has to be that emergency declaration. The state has to then request aid, and then it has to be formally approved. They have to all parties involved need to sign this resource support agreement or RSA, and then the resources are deployed. So because there are these issues with EMAC, there's some limitations, etc. There've been a lot of reforms in this space. So one of those possible reforms is there's a Uniform Emergency Volunteer Health Practitioners Act, UEVHPA, that was, I think, developed in 2006. And that was created so that there could be faster legal routes for getting credentialed healthcare volunteers in place. However, as of right now, I believe only 19 or 20 states have actually enacted that law. So it's not quite a perfect solution yet. So again, with EMAC, it's a really powerful tool. It can be really helpful, but it is a kind of negotiated process. It's not an automatic on-off resource immediacy kind of situation. So I wanted to give you some practical tips for navigating the differences across state lines in an emergency response around these legal issues. I think the most important thing you can do is to know your neighboring state's rules. So if you're in a metro area that covers 2 states, for example, which I think in Region 7 particularly, we have a lot of examples of that. Omaha, we've got Iowa just right there. You know, Kansas City is obviously right over 2 different states. Then you really should be aware of both states' laws in your metro region. By the same term, if you are in a more rural area where maybe patients are transferred from your rural area to a larger city in another state, you might want to be aware of that state's legal boundaries and legal authorities as well. I'm thinking in particular, you know, Western Nebraska. A lot of areas in that part of the state, they may not want to transfer patients or whatever the case may be to Omaha. Denver may actually be more convenient for them. So it'd be good for those folks in that area to have a good sense of what Colorado's laws are. So just think about what's most relevant for you and your practice and your community. Other thing I would say is establish contacts in those other states ahead of time. Don't wait till the emergency has occurred. We all know the benefit of preparation. But as much as you can, get to know people in those other states so that you have good rapport with them. And if maybe there are legal issues that come up that you don't readily have an answer for, those contacts that you have in that other state may be able to get an answer for you a little bit more readily. And you could probably do the same for them. And then finally, if you have surge staff that you consistently call on in an emergency, try as much as you can to maintain their credentialing files. Make sure you know that their credentials are up to date, that everything is good with their licensure and credentialing ahead of time, so that you don't have to jump through all those hurdles in the event of an emergency. All right, let's move on to federal and state waivers. So let's start with the basics. What is a waiver? So a waiver generally occurs when a statutory or regulatory requirement is relaxed or put on hold during an emergency. So generally, waivers are dependent on emergency declarations, either state or federal declarations, depending on what type of waiver we're talking about. These waivers are generally temporary. They typically only last for the duration of the emergency. They're not forever waivers. They're just for the duration of the given emergency. Now, I say that, and I will say, I believe an exception to that is many of the COVID-19 telehealth waivers that we saw in the pandemic. I believe those have been extended through September 30th of this year. So those may be an exception to the time duration of most waivers in an emergency. Another thing to know about waivers, they can generally be blanket waivers, which means they apply to every healthcare facility or whatever the case may be in an area impacted by an emergency. So we saw that a lot with COVID. There were blanket waivers that covered the entire country of common issues that would impact healthcare facilities during the pandemic. Or they can be individual waivers, which are unique to a given healthcare facility and specific to their given needs. So if you attended the part one webinar, you may recall that we talked about federal versus state emergency declarations. And as part of that, we talked a little bit about waivers as well. Not a lot, but just a little bit. So some of this may sound like a recap, but it is just a little bit different. So it's important that we distinguish between federal and state waivers as they have really different scopes and applicability. So on the federal side, we have a few different types of waivers that we see. First, and I think probably the most important for our purposes, is 1135 waivers. And they're called that. They're named after Section 1135 of the Social Security Act. 1135 waivers apply to the, 17 provider types under CMS, the Centers for Medicare and Medicaid Services. And you may recall this from last time, but 1135 waivers can only be issued if we have both a PHE or public health emergency declaration from the HHS or Health and Human Services Secretary, and we have either a Stafford Act or National Emergencies Act declaration from the president. So to get these 1135 waivers, both of those declarations have to be in place. So those types of waivers typically involve relaxing different conditions of participation for CMS covered entities. And they can also relate to relaxing parts of HIPAA or EMTALA, among some other regulatory processes. So we also have Stafford Act waivers. Stafford Act, you may recall, is the more emergency management side, less health focused law around emergency powers and authorities. So the Stafford Act, under Section 301 of that act, it allows federal agencies who are involved in disaster assistance to modify or waive certain administrative conditions so that they can more easily provide assistance. So there's a couple different types of waivers on that federal side. On the state side, every state, and we talked about this last time too, has laws in place that determine what powers their governor has to waive legal and regulatory requirements in an emergency. So these waivers typically come in the form of including waiver language in the executive order that contains the emergency declaration. So an important thing to remember here is that every state's specific authority for their governor and the powers that that governor has may differ. It's not the same across every state in the country. And as we've talked about before, governors and state emergency declarations can only waive state level laws and regulations, not federal. So always remember that state level declarations, state level waivers do not have an impact on federal laws and regulations, only state. So let's walk through the 1135 waiver process. So what triggers that waiver? What does that process look like? So remember, as we just talked about, for 1135, we start with those dual emergency declarations. We have the PHE declaration from the HHS Secretary, and then we have either a Stafford Act or National Emergencies Act declaration from the President. When we have both of those in place, CMS or Centers for Medicare and Medicaid Services can then start issuing these 1135 waivers. And so I think I mentioned this before, but when we had the COVID-19 pandemic, this was really interesting because we had a public health emergency declaration. I believe it was like a full month, maybe 3 weeks before we had a presidential declaration. So we couldn't start using or having 1135 waivers until both of those declarations are in place. So it's really critical to understand that piece of it. So CMS can then start issuing these waivers. If they issue a blanket waiver, facilities don't need to make a request to act under that waiver. It's just, that's the waiver that they can then begin acting under. But if there are specific things or additional waivers that your hospital or your facility needs, you can write a request for a specific individual waiver. So that request, it's a written request. You actually send it via email, I believe, including details about your facility, the specific regulatory or statutory waiver that you're seeking, and your justification for that waiver, why your specific facility needs that waiver. So that request is then sent to your CMS regional office. They review it, and once they approve it, the facility can then begin operating under that waiver. If you receive the waiver and you start to act under that waiver, even under a blanket waiver, I would encourage you to document everything. Document what waivers you have, track the dates of when those waivers are in place and when you can act under them. If you have an individual waiver from CMS, make sure you keep all that documentation so that you don't run into legal issues down the road or risk receiving sanctions or issues for not following certain regulatory requirements when you did have a waiver for those things. So document everything. So there's a few areas that we often see come up in waivers, particularly with 1135, but also with some state waivers as well. So with state waivers, we see a lot around licensure flexibility. So with the pandemic, we saw this quite a bit. We've seen it with other emergencies where governors, when they do an emergency order or emergency declaration and executive order, they may allow for out-of-state or retired or inactive licensed providers to practice without renewing their license or without getting an in-state license. So you may see those kind of flexibilities and waivers. There can also be waivers around billing and reimbursement. So sometimes Medicare, Medicaid may adapt some of their rules to allow for more time flexibility in submitting billing and reimbursement kind of paperwork and processes there. We've also seen a number of waivers, like I previously mentioned with COVID, around telehealth and expanding those capabilities, allowing for different types of medical appointments and providers to use telehealth services, maybe even across state lines. And then we also see some modifications to HIPAA. So you may see that there's some more flexibility around patient data sharing, or there may be reduced or paused sanctions for not following certain requirements of HIPAA. So anytime, these are the kind of areas that we see a lot with waivers, but anytime you have a waiver, make sure you check it really carefully to see what specifically is included in it so that you're acting under that umbrella. I wanted to provide a couple examples of real life waivers. The first one here is an executive order from then Governor Ricketts in Nebraska in 2020. This was an executive order around expanding telehealth. You get some bonus whereas content there. And then another example, this is from January of this year. This is where CMS issued some blanket 1135 waivers for providers and healthcare facilities who were impacted by California's wildfires and straight line winds earlier this year. So we do see these kind of waivers for natural disasters and types of emergencies beyond, a pandemic or something like that. We see them for all different types of emergencies. So these kind of waivers, they may seem like bureaucratic paperwork, but they're actually expanding healthcare facilities' ability to respond to an emergency or to a surge event. I just was going to check the chat real quick. I see there's something about HIPAA exemptions. Yeah, so HIPAA exemptions, there's quite a lot of them. So I'm just responding to this real quick as we go. There's plenty of different areas of HIPAA where you can disclose information that you may not expect to. We covered some of that last time, but make sure you look into that as well. HHS has a lot of resources about where there may be some flexibilities with HIPAA, particularly in emergencies. Okay. So I want to wrap up this substantive portion of our time together by looking at some ways you can integrate legal preparedness into your own existing facility preparedness efforts and operations. I think one way that you can do that is with a legal readiness checklist. You know, I don't know about you, I love a checklist. I feel like we use checklists a lot in emergency preparedness and response. So let's do that as well with our legal readiness. First thing I have on there are your policies, your plans, your procedures. Are they up to date? Are they ready for implementation? Are they compliant with current regulations? My former background before I was at UNMC was I helped a healthcare provider implement the CMS preparedness regs. I oversaw that process. And so I know there's a lot of those kind of CMS rules. There's all of these different things that you need to make sure are in place for your facility. So let's make sure your policies and plans are up to date and compliant before an emergency occurs. Second thing I would say, do you have contact info, phone number, email addresses, whatever, for any legal points of contact that you may need? You want to have that information before you actually need it. And you want to actually establish relationships with those folks before you need to reach out to them. They're going to be more likely to respond, they're going to be more likely to engage with you, etc. So as much as possible, kind of like we were saying about cross-state legal concerns, establish relationships with any legal points of contact before an emergency as well. And then do you have templates for waiver requests that you might need in an emergency? I'm going to provide you a link at the end to some potential resources for waiver request templates. But that's a good thing to have in place as well. If you know that there are certain types of waivers that you may be needing in the future, if you can have a template ready that you can just fill in with the specifics, that will set you up really well. Okay, this is something that I get kind of amped about. So forgive me if I get a little excited about this idea. But I really think one of the most practical things that you can do to gain comfort and familiarity around legal issues is to incorporate them into your exercises. If you're a healthcare facility under CMS, you know you have to do exercises. So why not use that opportunity to test out some of these legal concerns? It doesn't have to be the whole focus, but you can create injects that deal with legal concerns. I put this example on the slide. Nurses in a neighboring state want to volunteer and provide assistance to the emergency response in your state. What are the licensing and credentialing concerns? Excuse me. This is a simple inject that can allow for some really good discussion and an exercise, which you'd much rather have that conversation in an exercise than in the actual event, trying to figure it out on the fly. Also, I would really, really encourage you to invite public health lawyers or the counsel for your hospital or healthcare facility. Sometimes it's the compliance person to your exercise. To me, there's a lot of benefit in doing that. First of all, it builds connection with someone who you may not normally interact with, but who could be very, very helpful to your response. I think, as we've talked about previously, it allows you to build a relationship with this person before you need to call upon them. Second, it brings legal expertise to the table so that you're not trying to guess what the right legal answer is, but you're actually getting someone who's more informed on some of these concerns and topics. But then I think maybe most importantly, it lets the lawyers, it lets the compliance people, whomever, see what the actual practical concerns of a response are. Those folks may not always have the best perspective of what an emergency response actually looks like. So getting to see through an exercise what a response entails and where potential legal issues may exist can be really helpful to them to understand what you're doing, but also so that they can be aware of what legal issues may be most pressing so that they can educate themselves on how best to respond to those particular concerns or issues. So again, I think this is just an easy way to make you and your team, if you're at a healthcare facility, more comfortable with navigating legal issues in practice so that you're not as slowed down by them in the real thing in a response. Okay, so let's wrap it up real quick and then we can do some Q&A because I'm sure there are probably some questions. Wanted to give you some key takeaways about all three of the main areas that we looked at. Excuse me. So first of all, translating legalese. So as we covered at the beginning, legalese is intended to be complicated. It's meant to be complex and confusing. So take your time when you're trying to read statutes, contracts, whatever the case may be. Break them down into small parts. Use resources that are available to you to make it clearer, whether it's glossaries, whether it's a lawyer who can help interpret. Don't be afraid to use those resources to make your life easier as you try and understand legal documents or resources. For cross-state legal concerns, my primary thing as a takeaway would be aware of legal differences across state lines, and as much as possible, prepare ahead of time and get some mutual aid agreements in place. Those are going to save you a lot of headache and time and concern in the event of an actual emergency response. And then for federal and state waivers, make sure you familiarize yourself with what types of waivers might be available. You don't always know exactly what waivers are going to be available, but it's good to get a sense of what things may be and of what things you may want to request in the future. And as much as is practicable, develop those template requests. Biggest takeaway on all these things always is plan ahead. And I know I'm probably preaching to the choir here, but have your policies and your plans in place, your mutual aid agreements, those relationships in place before you need to use them. I did want to provide you with some resources here. First is that plain language legal glossary. Again, there's a ton of those out there. You can find some by Googling. This is, like I said, the one from the Nebraska Supreme Court. I think it's a good one, but if you don't want that one, you can find another one. There's tons of them. This second one, I wish I could show this to you, but I do not trust my own ability to do like a split screen share kind of thing. So I'm just going to tell you about it. This is the Emergency Law Inventory. It was created by Temple University, and this is a very cool website. I would encourage you to check it out. When you go on here, they've collected all these different state laws that relate to emergencies and emergency response. And you can go on there, you can pick what state you're looking for, you can pick what profession you're interested in laws relating to. So you can say like, I'm in Alabama, I want laws relating to a nurse. And then you can also filter it by laws that are dependent on whether they need to have a declaration in place or not. So it's a very cool resource. I would encourage you to check it out. Just mess around, play around on there, see what you can find. Also, I would say, similar to this webinar, don't use that as legal advice. It's a good resource, it's a good tool, it's a good supplement. It should not be the end-all be-all for legal advice. This is the CMS 1135 waiver page. I would encourage you to take a look at that. This is where you're going to find some information on template waiver requests. This can be really helpful. So bookmark that, save that if you're in a healthcare facility. And then I would be remiss if I did not include our RDHRE website, which I think has links to all the previous material as well. Okay, so with that, I will gladly take some questions. I've put my email address on there. If you're more comfortable sending me a question later in writing, completely fine. Just reach out. I'm happy to answer. So let me check the chat, see if we have questions already. Thank you, Thomas, for putting that emergency law inventory link in the chat. Hold on.
So I think in the chat, I'm not necessarily seeing questions, but we do have a few in the Q&A here.
Yeah, I see that. Okay, so I see the question, Russell, about what I mean in saying that legalese is intentionally hard to follow. Do I mean that as a strategy or a tactic? Some of this is just me sharing my opinion, but I think also the MIT article that I shared in the previous slides, they talk about this a little bit as well. So in terms of it being intentionally misleading, the things that I have seen is that lawyers are very used to this practice of using very archaic language. Some of that is just tradition, but some of it also, I think, is done to assert a certain level of authority and knowledge on a subject. We sound a lot smarter if we use really complicated words. So I think it's often used in a way that doesn't make it accessible to a lot of people. It keeps it kind of separate from what most folks can engage with. So that's why I think it can be intentionally confusing. Maybe that's not a fair way to depict it, but that is the way I have seen a lot of legal language being used. Deb, I see the question here about should and shall. Should is complicated. Should to me does not contain the same legal force as must or shall. If I see a must or a shall in a statute or a regulation, then yes, like that is something you have to do. A should to me falls maybe a little bit in between must and shall and may. I think it's probably still something that's best practice to do, but I'm not sure it has the same level of enforceability as a must or a shall. Okay, let me see this one. Public health and healthcare emergency management has many more regulations, statutes, and legal accountability than government emergency management operations. Agreed. Do you think we could propose more laws for local government or EM to follow? Is the hurdle for legal accountability and government considered to be immunity? I'm not sure what that last part of the question means, Ashley, if you don't mind clarifying a little bit in the chat or either in Q&A. But in terms of proposing more laws for local or government emergency management to follow, I don't know if that's the solution. This is strictly my opinion. I don't know if the solution is to have more laws for EM to make it more kind of even playing field with public health and healthcare, or if there needs to be a reduction, a reduction of some of the hurdles and obstacles that public health and healthcare have to face in emergency response. Those two things may not also be mutually exclusive. I don't know. Potentially, there could be more laws for local or government emergency management to follow. I think with the current federal landscape around emergency management, we're seeing so many changes with FEMA and maybe changes in how that is structured. I'm not sure that right now there would be a strong appetite for additional laws for emergency management to practice, but that's just my opinion. And fair point, Deb. So I thank you for adding that to the answer as someone at NEMA, Nebraska Emergency Management, that public EM has lots of rules, laws, and regulations that we don't know about. I appreciate you sharing that. And yes, there is always importance of knowing where someone's legal duty or jurisdiction lies and making sure everyone knows their lanes of authority. I appreciate you adding that, Deb. I think those were all the questions I saw on Q&A. And Rita, thank you for the kind comment in the chat. But if there were any other questions, we have about 3 minutes. I'm happy to answer anything, or else folks can get 2 minutes back.
I did want to point out there was one in here that I answered while you were talking because somebody was asking, saying it would be great if you could do a session on ethics, such as allocation of scarce resources. And I know that's something that we're going to be working on with Dr. Lowe, Dr. Abby Lowe, to do exactly that in the coming months here, because she's doing some separate work on exactly that, the scarce resources. So I don't know, maybe we bring you back for a guest appearance or something, but
You know what?
we'll see.
There's no one I trust more to talk about ethics than Dr. Abby Lowe. So she is going to be perfect for that.
We are looking forward to it. I am not seeing any other questions come in. So kudos on another great law presentation. I appreciate everybody's time coming and learning more for this, for whether you need to go back and review this information or you want to forward it on to someone else. In the next couple of business days, we'll get this recording edited and put up on both our website as well as our YouTube channel. And again, everybody who attended today will get links to that in your emails in the next couple of days. So it's meant to be a resource, and it's meant to be out there for you guys to all reference if you need be, and utilize as best you can. So with that, I thank Rachel for coming on today. I thank everybody for attending, and I guess we'll give everyone an extra minute back today.
Thanks, everyone.